Hey guys, this is Professor Robinson. So this is our second makeup class. This session is going to cover pages 891 through 910, and that includes two cases. First, we'll talk about the Armstrong case, and then we'll begin chapter 8 and our discussion of nuisance, and we will talk about the Birch case. Then next week on Monday, we'll pick up where we left off, and we'll start with page 910, and next week we'll work our way through pages 910 to 953. Okay, so I put up a timeline for you. There's a lot going on in this case, so hopefully the timeline will help you organize your thoughts about this case. I'll summarize the case, and then I will talk about specific points that I think you should take away from the case. So Armstrong owns lots in the Ledges of Hidden Hills subdivision, which I'll refer to as the Ledges from here on out. And the Ledges was developed pursuant to a recorded plat. And the facts tell us that there are 49 lots along two main roads that form a Y shape, and there are 4 cul-de-sacs in this development. The developer, Vogel Development Corporation, recorded a declaration of limitations, restrictions, and uses in 1988. And the declaration, at that time, the declaration just restricted the lots to single-family residential use. It established setbacks and provided for some architectural controls. The purpose of those architectural controls was just to make the neighborhood more visually appealing. Also in the declaration, a homeowners association, a HOA, was established, but the declaration in 1988 did not provide for the collection of dues by the homeowners association. So soon thereafter, the Vogel Development Corporation, they began conveying lots in the subdivision, and after several of the lots had been conveyed, Vogel decides to construct this lighted sign that is going to be the sign that is at the entrance of the development of the subdivision. Because the sign was lighted, it needed electricity, which meant that there was going to be an electricity bill. So what Vogel did in subsequent conveyances of lots to owners, in their deeds, Vogel included language requiring those homeowners to pay charges and assessments in order to take care of the ongoing utility bill that was going to be generated from this lighted sign at the entrance of the subdivision. Okay, so before the HOA's first meeting, the HOA had a 3-member board of directors, and that board of directors adopted some bylaws for the HOA. Then at that first meeting, the bylaws were amended, and they were amended in such a way that the amendments provided that the association could put a lien on any owner's lot who wouldn't pay an assessment. And then the association started charging lot owners for utility bills incurred for the lighted sign. And then HOA also started mowing the roadside. They also started charging owners for snow removal and then for operating and legal expenses. So no sooner than the HOA establishes itself, amends those bylaws, it starts charging owners for, in addition to the lighted sign, mowing, snow removal, operating, and legal expenses. So Armstrong, one of the lot owners, expresses some concern about these new powers of the association, and after she expresses that concern, the board then again amends the association bylaws and expands their powers even further. So in response to these expanded powers, the Armstrongs send a letter to the association essentially saying, look, we don't want to be a part of the association anymore. Please terminate our membership in the association. Of course, as the facts tell us, the Homeowners Association denies the request. So in response to that, the Armstrongs file a declaratory judgment action. So in response to, well, maybe not in response, but after the declaratory judgment action is filed by the Armstrongs, the association meets again, and the association this time decides to amend the actual declaration that was established and recorded in 1988. And you can read on page 894 in detail about the provisions contained in the amended declaration. The most pertinent one, I think, for our purposes is the amendment that essentially corresponds to the increased powers that the association gave itself when it amended the bylaws, right? And so the case, in the case, the court essentially talks about how the amended declaration is very different from the original declaration that was established and recorded in 1988. So the Armstrongs lose at the trial level. They lose at the North Carolina Court of Appeals. They petition for discretionary review at the Supreme Court of North Carolina. That petition is granted, and the Supreme Court of North Carolina reviews the case. And in sum, the Supreme Court of North Carolina reverses the Court of Appeals decision, and in doing so, they hold first that Armstrong and the other neighbors, they purchased their lots without notice of these new restrictions that the Homeowners Association is attempting to include in the bylaws and the amended declaration. And second, the Supreme Court says that the Homeowners Association, even though the declaration says that it could be amended, the Homeowners Association can't use that amendment provision to impose new and different covenants on the lot owners of the subdivision. So this case is really an exploration of the authority with regards to homeowners associations. So what authority do homeowners associations have? What is the source of that authority? And then what are the limits on that authority? So what are the sources of authority for a homeowners association? Well, first there is the declaration. And in this case, we saw that the declaration was established or formed by Vogel Development Corporation in 1988. So the declaration would be the first source of authority. Second source of authority would be in deeds to subsequent purchasers. So in the deed to subsequent purchasers in the Armstrong case, we saw that the Vogel Development Corporation did in fact put in those deeds that the owners of those lots had to pay an assessment. All right, so another source of authority for a homeowners association. Third, the articles of incorporation, and in the Armstrong case, it talks a little bit about the articles of incorporation that were filed on behalf of the homeowners association. Fourth, the bylaws of the homeowners association. So bylaws might be formed. In this case, in Armstrong, the bylaws were created and amended a couple times uh, unlawfully, as the court said, to give the homeowners association more and more power. And then finally, uh, the amended declaration. So it's not that a declaration can't be amended, it just has to be amended in a specific way. Generally, an amended declaration has to be, for the amendments to be approved, they have to be approved by a majority of the homeowners association members. And as we'll talk about in a moment, and as made clear in this case, the scope of those amendments have to be reasonable with respect to the original covenants, conditions, and restrictions contained in the original declaration. Okay, so what are some takeaways from this case? First, I would say that understand that the power of a homeowners association is limited to the powers granted to it in the declaration, right? So the declaration is the original document establishing the subdivision, and generally speaking, in the declaration, if a homeowners association is contemplated, its powers will be set out in the declaration, and then the homeowners association that is created after the declaration is limited in its power based on the provisions made for it in the declaration. So that's point one. Point two, the declaration can be amended by the homeowners association, but for those amendments to be recognized and enforceable, one, they have to be reasonable, and they have to be reasonable in view of the intent of the contracting parties. And then second, these amendments, they cannot exceed the purpose of the original declaration. Finally, in reviewing any amendments, the court is going to consider the legitimate needs of the HOA and the legitimate expectation of lot owners. So applying those principles to this case, first we have to recognize, if you look at the original declaration did not contain any covenants authorizing any assessments, right? So you had no common areas created in this original subdivision. Essentially, all the roads were dedicated to the public, so originally there were no assessments. We did have later, when Vogel installed the sign, we did have Vogel include in covenants include in the deeds to lot owners covenants authorizing an assessment to be taken from or to be paid by the lot owners to pay for the electricity sign. But the court says that that is a very narrow purpose that Vogel set out in those covenants. And you shouldn't interpret those covenants as providing the homeowners association with unlimited power to make assessments as they see fit. So given those two facts, the court looks at the amendments that the homeowners association made to the declaration, and this is on page 897 in your case book. And those amendments to the declaration authorize broad assessments for the general purposes of promoting the safety, welfare, recreation, health, common benefit, and enjoyment of the residents of lots in the ledges as may be more specifically authorized from time to time by the board, the court says that those amendments to make those assessments is unreasonable in view of the original declaration and in view of the very narrow purpose that the covenants to lot owners requesting that they pay an assessment for the utility bill for the sign, given those 2 points, the amended declaration is beyond the scope of what was intended by the original declaration. Okay, so a question to ask yourself or bat around in your study groups is, if you look at the language of the amended declaration, right, in the Armstrong case, the question is, would that language have been reasonable if it appeared in the original declaration? So when Vogel Development Corporation wrote the original declaration, if they had included the language that the HOA tried to include in their amendment, if that language was included in the original declaration, would a court consider it reasonable? Okay, so think about that. If you have questions about that, I'm happy to answer them, but that is a question just to promote some thought about the case and about what is reasonable and what is not reasonable with respect to the authority and power of an HOA. Okay, so that brings us to our final chapter of the year, Chapter 8, Government Regulation and Taking of Land. And as the chapter would indicate, in this section, what we're going to be talking about are public land use controls. We've talked about, in Chapter 7, we talked about private land use controls. And so in Chapter 8, we're talking about public land use controls. So the first case is the Birch case, and this takes place in West Virginia. And so we have the Public Service Commission granting Ned Power a certificate to construct and operate a wind power electrical generating facility. And so Ned Power enters into a contract to sell the facility, including 200 wind turbines, to Shell. And so 7 homeowners who live near the area where these wind turbines are going to go up, they file a complaint seeking to enjoin Shell and Ned Power from constructing and operating this wind power facility. And the homeowners say that, look, these wind turbines, they're going to increase the amount of noise that's created. There's going to be a annoying flicker that's created when the sun is at the horizon and you can view the sun through the wind turbines going, and that flicker is going to be disturbing. And they also say that there might be danger from blades that break off from the wind turbines, and all of these things would create a private nuisance. Further, the homeowners that are going to be near this wind turbine project complain that this wind power facility is going to actually reduce their property values. So at the circuit court level, the circuit court actually finds in favor of Shell and Ned Power, and the rationale from the circuit point perspective is essentially that the circuit court says we don't have jurisdiction to grant an injunction because the Public Service Commission already authorized this project. So the neighbors appeal to the Supreme Court of West Virginia, and the Supreme Court of West Virginia reverses the circuit court and remands the case. And in the holding of this case, what the Supreme Court of West Virginia says is that the court does have jurisdiction with respect to the injunction, and it also says that things such as noise, unsightliness, if it's combined or accompanied with other nuisances, and other activities that reduce the property value, may in fact be abatable nuisances. All right, so these wind turbines aren't all bad, and I am in the email that I send to you notifying you about making this class available online. I'm also going to include a link to a video, a short video that talks about the issues that people are having with regards to wind turbines in West Texas. So I think that would be a good. I would highly recommend watching that video, and then based on the video, which talks about some of the benefits of wind turbines, a question to think about and to think about amongst yourselves, to talk about in your study groups, is what does the West Virginia court do on remand, right? Do they issue this prospective injunction based on the complaints that the neighbors have made, or do they allow these wind turbine facilities to be constructed? All right. Okay, so that's it. Again, if you have any questions, please feel free to email me. Please go and watch the wind turbine video that I posted that accompanies the course. I think it will give you some good information and a broader perspective on this issue. And we will meet again on Monday, and I will see you guys then. Have a good weekend.